Greetings and welcome to IBI, India Business Insights. Today our video is on the National Company Law Tribunal. The National Company Law Tribunal, sometimes known as the NCLT, is a quasi-judicial body that decides disputes involving Indian corporations founded in accordance with the Companies Act of 2013. Following the recommendations of the V. Balakrishna Iradi Committee on the legislation pertaining to the insolvency and the winding up of the companies, this body was established by the Indian government on the 1st of June 2016 in accordance with Section 408 of the Companies Act 2013. The Company Law Board handled company-related disputes before creating to the establishment of the National Law Tribunal. The establishment of National Company Law Tribunal was proposed in 2002 in place of the Company Law Board, thanks to the revisions made to the Companies Act of 1956. The constitutionality of this was challenged and hence the establishment of NCLT was postponed. The BIFR Board, that is the Board for Industrial and Financial Corporation, and the Appellate Tribunal dealt with company concerns relating to defaults by company debtors. The High Court also made decisions on other merger and amalgamation cases. There was a need for a centralized organization to handle all company-related concerns. On June 1, 2016, the National Company Law Tribunal was established under the requirements of the Companies Act of 2013. In 2016, the Company Law Board was disbanded and its pending work was handled to the NCLT. Jurisdiction. After the formation of the NCLT, it acquired the jurisdiction of the following: Company Law Board, BIFR, that is the Board for Industrial and Financial Corporation, AAIFR, that is the Appellate Authority for Industrial and Financial Reconstruction, and the High Court. The above implies that the NCLT has the authority to discharge all the company matters related work of the three boards and the High Court. Additionally, this tribunal is responsible for handling Act-mandated actions, including arbitration, compromise, winding up, etc. Company law cases pertaining to civil court have been transferred to the NCLT, a special court. Powers and functions of NCLT. Class action, Section 245 of Companies Act 2013. An application may be filed to the tribunal by either the members of the company or by the depositors or on the behalf of the members stating that affairs have been conducted in the manner which is prejudicial to the interest of the company and seeking all or any of the following ground. The company may be restrained from doing any act which is outside the scope of MOA and AOA, from committing any breach of the provisions of MOA and AOA, and its directors from acting on such resolutions. Doing any act that is either contrary to the act or any other act that is in force for the time being. Declaring any resolution which in turn alters the MOA and AOA and becomes void if such resolution is passed. To claim either damages or compensation or to demand any other suitable action from or against company or directors of the company for any unlawful, fraudulent or wrongful act or omission committed by them, auditor or audit firm of the company for improper or misleading statements, can seek any other remedy from the tribunal. Liability of partners of audit firm. Where the members of depositors claim damages or compensation or any other action against the audit firm, the liability shall fall on the firm and each and every partner who was involved in making the improper or misleading statement. Eligibility of members and depositors under Section 245 for filling the application. The number of members for filing an application to the tribunal shall be not less than 100 members or members who are not holding less than 1/10 shares of total voting power in the company, in case the company is having a share capital. Not less than 1/5 of the people on the company's register of the members, in case the company does not have share capital. The depositors shall be not less than 100 depositors or not less than such percentage of total depositors. Order of tribunal under Section 245. The tribunal shall see that the members and depositors have acted in good faith while an application is made for seeking the order. The tribunal shall issue a public notice to be served on all of the members and depositors on the application made by the members or depositors. Where similar applications are made from jurisdictions other than the present one, the tribunal application shall be consolidated and treated as one application, and the class members or depositors shall be allowed to choose between the two applications. Multiple applications for the same cause of action shall not be allowed. The orders which are passed by the tribunal shall be binding on the members, depositors, auditor, which includes audit firms, advisors, experts, or consultant, and any other person associated with the company. If the company fails to comply with the order which is passed by the tribunal, the company shall be punished with a fine of INR 5 lakhs, which may extend to INR 25 lakhs, and every officer of default shall be punished with a fine of INR 25,000, and which may extend to INR 1 lakh and with the imprisonment of 3 years. If the tribunal comes to the conclusion that the application filed is found to be frivolous or vexatious, the tribunal shall reject the application and record the reasons in writing and shall order the other party to pay the cost which does not exceed INR 1 lakh. Oppression and mismanagement. Section 241 of Companies Act 2013 states that any member of the company who has the right to complain to the tribunal as per Section 244 of the Act 2013 shall file a complaint to the tribunal stating that the company's affairs are conducted in a way that is detrimental to the public interest, oppressive to him or any member of the company, or detrimental to the company. A material change that has been brought by the company which is against the interest of creditors of the company, debenture holders, and shareholders of the company, and it has brought significant change in the management or control of the company. For such reasons, the members of the company perceive that the affairs of the company have been conducted in a manner that is prejudicial to its interest. When the central government is of opinion that affairs of the company have been conducted in any of the below manners mentioned, and by that tribunal comes to the conclusion that it has been prejudicial to the public interest or in an oppressive manner, a member of the company is either guilty of fraud, misfeasance, persistent negligence, breach of trust, or is the default in carrying out the obligations and functions as per law, or management of the company has not been carried out as per the sound principles or prudent commercial practices. When a company is being conducted which causes serious injury to trade, business, industry, or when a company is being managed with the sole motive to defraud creditors, members, or being managed only for fraudulent or unlawful purposes which is against the public interest, it shall file an application to the tribunal for seeking appropriate remedy. So under this chapter, both a member of the company or even the central government can seek redressal and remedy from the tribunal. Investigation powers. Section 213 of Companies Act 2013 states, when an application is made to the tribunal by the company has a share capital not less than 100 members or members who are not holding less than 1/10 shares of the total voting power in the company, or a company having no share capital not less than 1/5 of the people on the company's register of members. When an application is made by any other person other than the member of the company to the tribunal stating one of the circumstances. Affairs of the company have been conducted only with the intent to defraud the creditors or the members or any of the other persons. Business is being conducted either for fraudulent or unlawful purposes. Business is being conducted in such a way it is oppressive to its members. Business is being formed only with the sole motive of unlawful or fraudulent purposes. Persons who are engaged in the formation of the company or management of its affairs of the company were either guilty of fraud, misfeasance, or misconduct towards the company or any of its members. When members of the company have failed to give all the information to the company relating to the affairs of the company, which they are expected to give, including the information relating to the calculation of commission payable to the managing director, or any other manager of the company, and the tribunal may, after giving the reasonable opportunity to the parties, the tribunal feel that the affairs of the companies should be investigated, and for such purpose, the central government shall appoint an inspector to investigate. Provided after investigation it is proved that the affairs of the company have been conducted only with the intent to defraud the creditors or the members or any of the other persons, business is being conducted either for fraudulent or unlawful purposes, or Business is being conducted in such a way it is oppressive to its members, or business is being formed only with the sole motive for unlawful or fraudulent purposes. Persons who were engaged in the formation of the company or management of its affairs of the company were either guilty of fraud, misfeasance, or misconduct towards the company or any of its members. Then every officer of the company who is in default and a person who is engaged either in the formation of the company or managing the affairs of the company shall be punished for the fraud. Deregistration. Section 7(7) of the Companies Act 2013 states if the tribunal comes to the notice that the company at the time of incorporation of the company furnished false or incorrect information, or by suppressing any material facts, information, or any declarations is filed by the company, the tribunal may pass any one of the orders as mentioned below. Pass such orders as it thinks fit, pass orders for winding of the company, direct the liability of members shall be unlimited. Reopening of accounts. Section 130 of Companies Act 2013 states that, except on the order of central government, income tax authorities, SEBI statutory body, the order made by a court of competent jurisdiction or tribunal, the company shall not open its account or recast its financial statements and shall be allowed to do so when earlier accounts were prepared in a fraudulent manner, affairs of the company were mismanaged and casting a doubt on reliability of financial statements. Before passing such orders, the tribunal shall give the notice to concerned authorities. Refusal to transfer shares. Section 58 of the Companies Act 2013 states, a private company which is limited by the shares or the public company which refuses to register the transfer of shares of the transferor, the company shall within 30 days of transfer shall send a notice to the transferor and transferee of such refusal. The transferee in return shall file the appeal to the tribunal within 30 days from the date of receipt of the notice, and in case no notice is sent by the company to the transferee shall file an appeal to the tribunal within 60 days from the instrument of the transfer. The tribunal shall hear the orders, and after hearing such orders shall either reject the appeal or order the company to transfer the shares within 10 days of an order, direct rectification of the register, and also direct the damages to be paid, if any, sustained by the aggrieved party. If any person contravenes with the order, shall be punishable with imprisonment for a term which shall be not less than 1 year, but may extend up to 3 years, and with the fine which shall not be less than INR 1 lakh, but may extend to INR 5 lakh. Conversion of public company into private company. Section 13 to 18 of the Companies Act 2013, read with Rule 41 of the Companies Incorporation Rule 2014, state that when a company converts from a public company into a private company, the approval of the NCLT tribunal is required for such a conversion. The tribunal may impose such terms and conditions as in Section 459 of the Companies Act 2013. Annual General Meeting. According to Sections 97 and 98 of the Companies Act 2013, if the members of the company fail to convene the meeting within a certain time, and a member of the company may apply to the tribunal to convene such a meeting, the tribunal has the power to convene those meetings. Winding up of the company. Section 242 of the Companies Act 2013, a company may be wound by the tribunal when the affairs of the company have been conducted in any one of the below manner set under Section 242 of the Companies Act 2013, and by that tribunal comes to the conclusion that the company has been prejudicial to public interest or in an oppressive manner. Additional powers. Section 221 of Companies Act 2013, power of the tribunal to freeze the assets of the company. Section 2, subsection 41 of the Companies Act 2013, power to change the financial years of the company registered. The NCLT will now have the authority to compound offences under the Act, and it will also have the authority to approve any compounding cases that exceed the set monetary threshold. The NCLT has significant authority to approve all arrangements, compromises, and amalgamations. NCLT and NCLAT has exclusive jurisdiction, so it will solve the question of multiplicity of jurisdictions. With the formation of NCLT, there will be a quick remedy for addressing corporate law problems, and they will be resolved quickly. The presiding judges are a mix of technical and judicial professionals, resulting in more sound and effective decisions. NCLT has multiple branches and benches, thus, it helps in providing justice at close range. It would also minimize the number of lawsuits filed before various forums and courts, thus saving time. NCLT and its appellate authority have now been operating for 5 to 6 years. This may be a good time to evaluate the impact of its 5 to 6 years of existence. So that will be a topic for another video. So if you like this video and for more such videos, like, share and subscribe to India Business Insights.